Good morning, everyone. Welcome to Miller Johnson's webinar for May 14th, 2020. My name is John Piggins. Today we're going to be focusing on Chapter 11 bankruptcy matters. As COVID restrictions ease and companies get back to work, some companies will not have sufficient resources to pay all of their debts because of their loss of income during the COVID crisis. This may force them to consider Chapter 11 in order to survive. So we intend to focus on Chapter 11 bankruptcies today, how they work, and what to expect if you're involved in a Chapter 11, either as a creditor or if your company is considering using Chapter 11 as a tool to survive after businesses reopen. My name is John Piggins, as I mentioned. I'm a member here at Miller Johnson. I have over 35 years experience practicing bankruptcy law, representing debtors, creditors, and bankruptcy trustees in all manner of bankruptcy cases. I also represent creditors and debtors in out-of-court workouts, so I have significant experience in this area. With me today is Loic, Dimithe, associate in our business section, who focuses on mergers and acquisitions, corporate finance, and bankruptcy law. As is our practice, we're going to start today by outlining current events related to the COVID-19 crisis. So I'm going to turn it over to Loic to start that outline for you. Loic?
Thank you, John, and good morning to everyone, and thank you for joining us this morning. Just some high-level statistics are the global count for confirmed COVID-19 cases has reached 4,347,015. Global death toll currently sits at 297,197 deaths. In the U.S., we have approximately 1,390,406 cases and 84,119 confirmed deaths. And then sticking closer to home here in Michigan, we've got confirmed case count of 48,219 with 4,714 confirmed deaths. Continued local news, there is a planned protest for today, Thursday the 14th of May, again on the Capitol here in Michigan. The Facebook group that was historically organizing these protests shut down. So it's a bit unclear as to how many people plan on attending the protest. The Capitol building is closed, and we can expect a heightened police presence at today's protests. I'm told, although we'll see how this actually plays out, that law enforcement officials will be actually enforcing and issuing citations for those violating the stay-at-home order and violating social distancing practices. The state of Michigan plans on furloughing about 64% of its workforce by requiring people to take at least 2 days off between now, I believe, June or July, in an effort to save $80 million on the budget. It's planned that these individuals will not be taking advantage of state unemployment benefits, but will instead be making use of the federal unemployment benefits as a means of supplementing their income during the temporary full furloughment. And then finally, in Wisconsin, the Supreme Court recently struck down the state's stay-at-home order. It was argued by local business owners and local residents that the order was harming them by prohibiting them from working and ultimately harmed the state's economy. The order was rescinded, and the governor has issued a statement condemning the decision, outlining that this decision will likely have long-term detrimental effects to the state, both in terms of the general welfare of its residents and in terms of its long-term economic prospects. So with that, we're going to go ahead and jump into today's presentation, just the nuts and bolts of corporate bankruptcy and overview, focusing on Chapter 11. Again, the presenters are myself and John Piggins. We have our usual disclaimer. I encourage individuals to take note of these webinars and any information that we put out, and understand, although many of you are our clients, understand that this is for informational purposes only, and we strongly encourage you to follow up with John or myself or any other member of the Miller Johnson team for further guidance on anything that you may hear or see coming out of Miller Johnson. So for today, as we've highlighted, we're going to focus on Chapter 11 bankruptcy, beginning by providing some key bankruptcy concepts, a brief introduction into Chapter 11, then going over in a little bit more detail some restructuring tools, the plan process, and then finishing off with the new SBA Chapter 11 provisions and some practical guidance for today's market. So starting off with a key concept that is really applicable in all bankruptcy cases is just some cost considerations. Bankruptcy generally comes in two forms, the prepackaged or prearranged form for the free-fall bankruptcy. The prepackaged form, as the name implies, is pre-negotiated form of bankruptcy in which the debtors and creditors come together before filing to come to an agreement as to their plan and how things are going to look post the bankruptcy proceeding. Whereas the free-fall form, there is no pre-arrangement or limited pre-negotiations, and a lot of the details are sorted out throughout the bankruptcy process. The trend is moving towards the prepackaged form in an effort to reduce costs and to expedite the process, but notwithstanding this prearranged, prepackaged option, the bankruptcy process can be quite costly and quite burdensome on the debtor in particular. So this cost and the burden on the debtor should be really taken into consideration in terms of planning when to go into bankruptcy, how you plan on navigating that process, and ultimately what you expect the debtor to look like after the bankruptcy process. In particular, in addition to some of the economic costs, debtors will likely have to devote at least one full-time employee, particularly at the outset of the process, to coordinate the bankruptcy process, coordinate information with the various creditors, and to coordinate with the bankruptcy trustee. And so debtors will want to consider how to manage both the economic burden and the personnel burden well in advance of actually filing. The next high-level consideration is understanding the bankruptcy estate itself. And so you want to understand that the estate constitutes all the assets and interests of the debtor, both pre-filing, pre-petition assets, and any assets or interests that the debtor may come into after filing, so post-petition assets. It's very broadly interpreted to include all the assets of the debtor, tangible or intangible, current or future assets. And so once the debtor and the assets become part of the bankruptcy process, it's not impossible, but it's difficult for the process to be dismissed and for the assets and the debtor to be freed from bankruptcy procedures and the purview of the bankruptcy court. In light of what's going on with the world in COVID-19, an important aspect of the bankruptcy estate is the valuation of the estate and the enterprise as a whole. And so the valuation process impacts a number of aspects of the bankruptcy process, from determining the use of cash, the right of secured creditors and unsecured creditors, and ultimately getting the plan approved and processed. And so the difficulties that the current climate, the current COVID-19 pandemic is creating and will likely continue to create with regards to valuation and maintaining the value of the debtor's assets, and the value of the enterprise as a whole will likely have a significant impact on the bankruptcy process, and particularly with regards to financing and other things like that, which we'll get into shortly.
Yeah, Loic, if I might chime in right here, I think that the reduction in value of assets, if any, that COVID-19 may create for a particular company stems from the fact that there are going to be a lot of companies liquidating their assets, and so the market is going to be flooded with assets that are for sale or being auctioned, and so the assets that the company has are going to necessarily be worth less. As a result, that may help the debtor because when putting together a plan of reorganization, there's a minimum bar that the debtor has to meet to pay creditors, secured creditors, and that is that they have to pay them at least what the assets would be worth if they were liquidated. So because of the COVID-19 effects, I think that may help the debtor pay less to secured creditors in a Chapter 11 under these circumstances.
Thank you, John. The next key concept here is understanding the automatic stay and how that affects the bankruptcy process. And so the automatic stay kicks in at the outset of the process and really is designed to protect the debtor, prohibits any attempt to collect pre-petition debts, prohibits commencement of judicial or other proceedings against the debtor, prohibits efforts to create or perfect any type of encumbrance or lien. Goes on to prohibit any effort to take possession or control of the collateral of the debtor, enforcement of any rights against the debtor, and set off against any pre-petition debt. So it's a pretty comprehensive shield that protects the debtors who may be experiencing a great degree of pressure from various creditors or other business-related pressures. Although pretty comprehensive, it is not absolute, and so it does not protect against actions against non-debtors and non-estate property. So you want to think about guarantors or other assets that may secure the underlying indebtedness. Does not stay, is not applicable to actions brought by the actual debtor. And although it is a pretty powerful form of relief for the debtor, it can be lifted by the various creditors. And of course, there are certain exceptions, such as police powers or other safe harbors that creditors may be able to take advantage of. John, I don't know if you wanted to add anything more on the bankruptcy automatic stay and powers.
One comment I would have is that when we say the state does not prevent actions against non-debtors, many times debtors will ask me, the principals of the debtors will ask me if the automatic stay protects them, and the answer is generally no. Typically, the principals of the debtor are the guarantors, and unless you can meet a very stringent, very narrow test to have the automatic stay apply to the principals of the debtor, it will not apply, and court holdings, even when they apply it for a very a short period of time. Loic, you want to move on to the next?
Thank you, John. So just an introduction into Chapter 11. It really serves generally two purposes, and we're talking about restructuring, both fiscal restructuring and operational restructuring, with fiscal restructuring focusing on changing the debtor's balance sheet items, and operational restructuring focusing on rearranging some of the operations of the debtor. The process generally can be used strategically as well. For example, for purposes of obtaining assets and entitled to assets free and clear of all liens. Can be used to clear up portfolio company investments to the extent that a certain investment may be underperforming. And then it can also be used by opportunistic lenders, particularly in large bankruptcy cases by providing financing and other forms of financing, which we'll get into shortly.
Loic, maybe if I could just chime in here. I think one of the major reasons smaller companies file bankruptcy is to buy time. Because of the automatic stay, creditors are on hold and they can't take any action against the debtor. So it gives the debtor some breathing space to kind of step back, try to get itself organized, buy some time where it doesn't have to pay any pre-petition debts, and hopefully come out the other end a stronger company that can be profitable either after shedding unprofitable assets through sales or simply restructuring through other methods.
Thank you, John. So when a debtor first files, there's a series of first motions that the debtor will want to file in order to coordinate the bankruptcy process. And two motions in particular that are really relevant is how the debtor is going to finance the bankruptcy process. And so motions with regards to cash collateral, to the extent the cash of the debtor is collateralized, any creditor has a security interest in the cash of the debtor is completely prohibited from making use of that cash regardless of the purpose. And so the debtor is going to want to either get approval from the creditor or from the bankruptcy court to approve the use of that cash throughout the process so that the debtor can continue to operate. We spoke briefly about the effects of COVID-19 on the market and in the bankruptcy process. I think in effect this point in the process as well with regards to obtaining consent from a creditor to make use of the cash collateral. Obviously, and creditors are going to be a bit more scrutinous of the debtors in cases where, just given the dynamics of the market, the creditor may have concerns about the use of the collateral and whether it's going to be used in a manner that's ultimately beneficial for the enterprise. A second source of financing that the debtor likely turn to or hopes to turn to is debtor in possession financing or DIP financing, which is a court-approved form of financing that allows either an existing creditor or a new lender to come in and provide financing to the debtor for purposes of navigating the bankruptcy process. The terms of DIP financing can be particularly attractive for some lenders in terms of the degree of security and priority that this form of lending provides and the interest that can be available. But again, going back to just the state of the market, debtors may find it increasingly difficult, just given the tightening of the credit markets, increasingly difficult to find lenders that are willing and able to provide DIP financing. But nonetheless, these are two considerations that all debtors should take into account when considering bankruptcy and when first filing, making sure that you have access to capital to continue to operate throughout the process. Another thing that you'll immediately come into contact with is the United States Trustee's Office, which is generally responsible for overseeing the administration of bankruptcy cases. And so when a debtor first files, the Trustee's Office conducts formation meetings with the creditors. It oversees professional retention and fees. And in particular, when you first file, you'll have the initial debtors conference where the Trustee's Office and the debtor, along with their counsel, will just generally sit down, review, and discuss just preliminary matters of that particular case, discuss the debtor's rights and responsibilities, and the trustee will likely at that point try to nail down a timeline and a time frame for proposing and ultimately finalizing the plan of restructuring. A second prominent group that debtors will come in contact with is the Creditors Committee. It's just a group of unsecured creditors instead of working individually with each unsecured creditor. They'll form a committee, and that committee will represent the unsecured creditor's interests. Now, you'll see this more often in larger cases, in smaller cases, particularly with creditors that have relatively small interests. It's time-consuming and costly, and so oftentimes in smaller cases, a creditors committee will simply just not be formed. And then finally here, just some other typical creditors that the debtor will have to either notify and coordinate with as part of the bankruptcy process. Things like banks and your traditional lenders, other institutional debt holders, lessors, landlords, taxing authorities, other individuals that hold claims like wages, commissions, etc., equity holders. All these individuals will have an interest and a stake in the proceeding. And with that, we move into part 3, and I'll turn it over to John to run through some restructuring tools in Chapter 11.
Thanks, Loic. So if you want to jump to the first slide, typically in a bankruptcy, the debtor has several options depending on the status of its business. Obviously, a Chapter 11 is meant to buy time because the automatic stay prevents creditors from taking any action against it. So at that point, it needs to decide whether it wants to simply use that time to try to build up its revenues and come out the other end more efficient and profitable, or if it wants to consider selling some or all of its assets through Chapter 11. And that's what we refer to as a Section 363 sale. Asset sales through Chapter 11 are sold free and clear of liens. That makes these sales attractive to potential purchasers of these assets. Not only do the purchasers get the assets at probably a discounted price because they're being sold by a bankrupt debtor, but they also get them free and clear of liens. So there is an attraction there. And to the extent that the debtor wants to sell assets that it thinks are underperforming, or a division of its company that is underperforming, this is an opportunity to do that. And I've seen situations where debtors have been negotiating for the sale of a division of their company with a potential purchaser, and the purchaser simply insists that the debtor file bankruptcy so that it can get the assets free and clear of liens. Again, a Chapter 11 can take many forms, and one of the forms also is that the debtor simply sells its entire organization as a going concern as opposed to some of its assets. So there's a myriad of possibilities of asset sales on that spectrum. The downside of the C363 sale is that it is expensive. The court, in order to approve a sale, will require that the sale be robustly marketed depending on the type of company and depending on the type of assets. That may mean a significant amount of marketing time nationwide, which is expensive. Typically, the court will not allow a sale to a specific buyer that is identified in advance unless the assets are also marketed generally to any other interested party. You want to move to the next slide? So this mentions the retention of an investment banker, business broker. That is what the debtor would probably be required to do if the sale is of some significant assets, and the court is going to require a robust marketing process. There's also the bidding procedures motion, which again adds expense and a step to this process in bankruptcy. You have to agree on the bidding procedures with the various constituencies in advance. So all of the creditors of the case are going to have an opportunity to weigh in on what the bidding procedures should be, and they're all going to try to negotiate a bidding procedures order that benefits them the most. The purchase agreement also typically with a buyer with what we call the stalking horse buyer, which would be the first offeror, is made public. The purchase offer is part of the pleadings so that anyone who looks at the case can go online and see the exact terms of the purchase offer, and any competing bid would have to agree to sign a purchase offer that is identical or very similar to the purchase offer that has been set forth going forward. Loic, if you want to move to the next page. So again, a sale is beneficial to the debtor if it can shed assets that it no longer uses or an unprofitable part of the company. Again, sale is free of clear of all liens, so creditors are going to be enticed to buy these assets because they know there won't be any claims against the assets. Assumption and assignment of executory contracts and unexpired leases may also be a benefit to a potential buyer. If a debtor or a part of the debtor's company has a favorable lease for real estate or a favorable contract with a supplier or any other company, that contract or that lease may be assumed by the debtor and assigned to the buyer so that the buyer gets the benefit of those terms. There are certain hoops that have to be jumped through in order to get the leases or contracts assumed and assigned. All of the past due amounts on those contracts have to be paid in full, and you have to present proofs to the court that whoever the lease is being assigned to or whoever the contract is being assigned to has the wherewithal to perform the contract for the duration of the contract period. So that does require typically a court hearing and is an expensive, time-consuming process. But in the end, if it's a beneficial contract, it is certainly going to benefit the buyer and would be an enticement for a buyer to get involved in purchasing assets. I'm going to move to the next slide. So here are some of the issues with regard to assuming contracts under the Bankruptcy Code. It can assume, debtors without even selling the assets can assume contracts that are favorable to them. Again, a lease that has a very good rate, below market rate, it's going to want to assume if it wants to keep that space. It can reject contracts and leases. This is solely up to the buyer. Up to the debtor. If the debtor does not want a certain contract or certain lease, it does not have to keep that contract or lease. It is not forced to do that in Chapter 11. It can reject that contract or lease without any court intervention. The decision whether to assume or reject a contract or lease is typically held by the debtor until its plan of reorganization is confirmed. The one exception is commercial leases of real estate. They have to be assumed or rejected within 120 days of filing a bankruptcy case, which can be extended, but typically you only get one extension and you have to present proofs to show why that extension is necessary. Next slide. So during the bankruptcy case, contracts and leases have to be performed by the debtor, especially if it's going to be assumed. first, the counterparty to the contract cannot terminate the contract or lease unless the contract or lease terminated by its own terms before the case was filed. If it hasn't, then the debtor has control as to whether or not they want to terminate or continue with the lease or the contract. The contract or the lease is, again, assumed or rejected by the debtor before the bankruptcy plan is confirmed. That's the time period within which the debtor has to make that decision. However, a creditor or a counterparty to the contract can file a motion with the bankruptcy court demanding that the debtor make a decision whether to assume or reject prior to that deadline. If the counterparty, the contract, presents adequate business reasons as to why that contract should be assumed or rejected earlier, the counterparty of the contract may get the benefit of finding out earlier whether or not its contract is going to be assumed or rejected. During that period, however, the debtor is required to make payments on the contract that have come due after the bankruptcy was filed. Again, the automatic stay prevents it from making any payments on the contract that were due before the bankruptcy was filed, but post-petition obligations must be paid in a timely manner. And again, as it says at the bottom, decision to assume or reject is generally determined on a business judgment basis. So even if the debtor wants to assume a contract, the court is going to determine whether or not the debtor has used its best business judgment in order to assume that contract if there are objections to its assumption. Move to the next slide. Loic? Thanks. The other aspect that comes up in a Chapter 11 with unions is the collective bargaining agreement. The debtor can modify or reject pre-petition retiree obligations and reject pre-petition collective bargaining agreements, but the standard for doing so is relatively strict and it differs from district to district, so you have to be aware where the case is pending before you determine what proofs are necessary in order to modify or reject. Typically, what has to happen is the debtor has to have used its best efforts in good faith to negotiate a consensual resolution or change in the bargaining in the contract before it's going to be allowed to reject that contract. Many union cases are filed in a situation where a buyer for the debtor has been identified, but the buyer does not want union employees. Many times the case will be filed in order to not only sell the assets to this buyer free and clear of liens, but reject the bargaining agreement so that the buyer can take the company and move on and operate without the union. The proofs in order to obtain that relief are fairly strict and, as I say, are different in different jurisdictions, but that is often an incentive for a company to file bankruptcy, especially if they've identified a buyer and the buyer wants the business without the union contract. Move on to the next slide, if you would. So the next part is the planned process. Once a company gets into bankruptcy, its entire goal is to move through the bankruptcy as quickly as possible, propose a plan of reorganization or plan of liquidation, which basically is a contract between the debtor and its creditors telling the creditors how they're going to get paid and how much they're going to get paid. That contract then has to be voted on by the creditors and has to be approved by the bankruptcy court. This slide outlines the different types of plans that debtors sometimes put together. A standalone plan is sometimes what we call a bootstrap plan, where the debtor simply pulls itself up by its bootstraps. The time that it has been given during the Chapter 11 to take a deep breath has allowed it to get back on its feet, and it can simply come out of Chapter 11 as a profitable company, maybe downsize somewhat, but then it sets forth in the plan that it's going to pay creditors, how it's going to pay creditors, over what period of time it's going to pay creditors. And when I say creditors, I mean it's pre-bankruptcy creditors. Part of the plan could also be to obtain financing from a third party as it moves out of bankruptcy and incorporate that into the plan provisions. We've covered the sale of assets that typically generates some cash which a debtor can use to fund its plan of reorganization as a smaller company coming out of Chapter 11. Merger and consolidation is also an option, either with a related entity that's in bankruptcy or with a non-bankrupt company coming out of the Chapter 11, which then assumes the obligations under the plan of reorganization. The plan of reorganization is typically a negotiation. The debtor typically sits down with the various constituencies, the unsecured creditors committee that we mentioned earlier, the secured creditors, other lenders, and other constituencies to determine how much each creditor class is going to get and how, over what period of time they're going to be paid. Creditors are typically put into different classes depending on what priority their claims are entitled to under the bankruptcy code. So each class of creditors has to be paid exactly the same. So all unsecured creditors have to be paid the same. They can't, in the same terms. Some unsecured creditors can't be paid differently than others. The same applies to a bank or a secured lender, but those lenders are typically put in their own class individually. And then taxes, again, all paid the same way. So, Loic, if you want to move to the next slide. As far as the plan is concerned, the debtor typically has 120 days to propose a plan. No one else can propose a plan during that period of time. And it is typical for a debtor to be able to extend that period. I have seen situations where that extension goes 240 days or longer based upon an order from the bankruptcy court because of the debtor's financial situation during the Chapter 11. After that exclusive period expires, however, other creditors can propose plan of reorganizations or plan of liquidations. Typically, if you have a competing plan, it's the plan filed by a bank or secured lender that simply wants the debtor to close its doors, be auctioned, and all of the proceeds be distributed to the creditors, in which situation the secured creditor who's proposing the plan would get most or all of those assets. Once a plan is confirmed, it has 60 days in which you can get it, once a plan is proposed, you have 60 days in which you can get the plan confirmed. If you fail to do that, then you're back to square one, and a new plan has to be proposed either by the debtor or one of the creditors. Loic, we're going to move to the next slide. So once the plan is filed with the court, the debtor has to also file a disclosure statement. Disclosure statement basically describes the debtor's history, how the debtor got to this point, and what the debtor sees as its financial future. One of the most important portions of the disclosure statement is typically projections, financial projections made by the debtor's accountant or financial professionals to estimate how much the debtor is going to obtain through operations or otherwise, and how that money is going to be distributed over the life of the plan. So a credible and experienced financial professional is very important in Chapter 11, because typically if the plan is contested, that financial professional, you're going to need to put them on the witness stand in order to testify as to why the projections make sense for this debtor and why this plan is feasible and why the debtor can pay the amounts that it is proposing to pay to creditors. Creditors and interest holders are allowed to vote on the plan. Typically, as I said, creditors are in different classes, unsecured creditors all in one class. In order to have the plan confirmed with consent, creditors have to vote. More than 50% in number of the creditors who vote have to vote in favor of the plan, and those creditors have to hold at least 2/3 of the amount of debt owed to that class in order for the plan to be confirmed. Loic, if you'd like to move to the next slide. So the plan process. The confirmation process, again, the court has to approve the plan of reorganization or liquidation. The plan is confirmed if it meets all of the criteria set out in 1129 of the Bankruptcy Code. Some of those criteria are set forth on this page. Again, as I alluded to much earlier in this, the creditors have to receive at least as much as they would have in a Chapter 7, and the case was liquidated. I think that relates to where COVID affects that, because it's going to reduce the amount of money that is that minimum amount. The creditors all have to vote, as I said, in specific numbers in order to have the plan confirmed on a consensual basis. I think we can move to the next slide, Loic. So if the plan is not, if the creditors do not vote in favor of the plan, as long as one class of creditors has voted in favor of the plan, the debtor has the opportunity to ask that the court approve the plan in spite of the fact that the creditors have not voted in favor of it. And this slide generally sets out the criteria that have to be met by the debtor if the plan is going to be confirmed over the objection of certain creditors. Basically, the main aspect of this is that the plan cannot pay one class of creditors any money if a class with a higher priority is not being paid in full. As long as that is the case and you meet the other criteria, you may have an opportunity to have the plan confirmed over the objection of some of the creditor classes. Next slide, Loic. So once the plan is confirmed, it is a binding contract between the debtor and all of its creditors. The pre-petition obligations are replaced by the terms of the contract as to the amount and to the timing of the payment. Then once the plan is performed by the debtor or at least performance of the plan is commenced, the case will typically be consummation of the plan will have been deemed to occur, and the reorganized debtor will emerge from bankruptcy, and it will have that contract between itself and its creditors going forward, which it has to meet the terms of. If it doesn't, a creditor can then go back into bankruptcy court, reopen the case, and have the case converted to a Chapter 7 liquidation, or it can go to state court and try to enforce that contract. Typically, we don't see that, but it is a possibility for a creditor who is not being paid under a plan that was confirmed possibly months or years prior. Loic, if you'd like to move to the next slide. So the next part of this, I think, is going to be very important for the people on this call, and that's the new Small Business Reorganization Act that was enacted by Congress in February of this year. This act was meant to streamline the process for small businesses to reorganize and rehabilitate their financial affairs. As we alluded to earlier, it's Chapter 11 is expensive and it's time consuming. This act was meant to reduce the time for a small business to go through a Chapter 11, and therefore reduce the expense that a small business might have. You're going to move to the next slide, Loic. So the definition of a small business under the original act was a debtor engaged in commercial or business activities. The debtor's non-contingent liquidated debts could not exceed $2,725,625, and 50% or more of those debts must have arisen from commercial or business activities. The third bullet point seems kind of obvious until you understand that the small business debtor can be an individual. So if you have an individual that meets these criteria and 50% or more of that individual's debts arose from commercial or business activities, that individual could file a small business Chapter 11. This is typically seen in a situation where you have a guarantor of significant business debt or an individual operating as a DBA. Loic, if you want to move to the next slide. So the CARES Act, which obviously was enacted after the COVID crisis began, also addressed the Small Business Reorganization Act for Chapter 11 by increasing the debt limit for a small business from the $2,700,000 and some that we talked about earlier to $7,500,000. As a result, this is going to allow significantly more businesses to file as small business Chapter 11 debtors. This is going to be very helpful, I believe, as we come out of the COVID crisis, because it's one more tool in a small business's toolbox in order to help it get back on its feet, allow it to buy time in order to reorganize its affairs, maybe sell off some of its assets, and get back on its feet so that it is operating profitably. Loic, if you want to move to the next one. So the difference between a traditional Chapter 11 and a small business Chapter 11, which all of these differences are designed to reduce the time and expense related to Chapter 11 for these smaller companies. So only a debtor can file a plan. There's no exclusive period that expires where a creditor can jump in and file a liquidating plan. However, the plan must be filed within 90 days of the bankruptcy filing. You can get a short extension of this, but very short. Typically, if the plan is not filed, you're going to find that the court is going to want to liquidate the company or dismiss the case. The plan confirmation standards are less rigorous. The plan can be confirmed over creditors' objections, even if all creditors are not paid in full, and creditors don't get to vote on the plan in a subchapter 5. As long as the plan meets certain criteria that are set out in the bankruptcy code, most notably the fact that the debtor has to put forth 100% of its unnecessary income, income that is not spoken for by operations or other necessary expenses. As long as it puts 100% of that income toward payment of its creditors and the plan meets other criteria, the debtor is going to be able to get the plan confirmed, and creditors do not have the opportunity to vote. They can file objections to the plan, but they can't vote on the plan. There's no creditors committee appointed. Typically in a larger case, a creditors committee it works diligently on behalf of creditors and is actually paid by the debtor, and its professionals are paid by the debtor, which significantly increases the expense of a larger Chapter 11. In the small business Chapter 11, there is no creditors committee, so that additional expense is not there. In a traditional Chapter 11, there typically is no trustee. The debtor operates as what we call a debtor in possession. In a small business Chapter 11, although the debtor continues to operate its business in the same manner as a debtor in possession in a larger bankruptcy case, a trustee is appointed immediately at the beginning of the case. The purpose of the trustee in this case is simply to help the debtor put forth a reasonable plan of reorganization. So it is basically he or she is a consultant with the debtor to try to put together the best plan of reorganization for the creditors given the debtor's circumstances. Loic, if you want to move to the next slide. More differences from the traditional Chapter 11, which again eliminate quarterly fee, which in a larger Chapter 11 can be fairly expensive, tens of thousands of dollars a quarter. These are eliminated in a small business Chapter 11. Administrative expenses, attorney's fees, accountant's fees, other professionals that are hired by the debtor. Those fees do not have to be paid immediately by the debtor as they do in a Chapter 11, immediately upon plan confirmation. They can be stretched out from 3 to 5 years after plan confirmation as part of the plan payments. Basically, these are all designed, again, for a small business debtor to be able to move through the Chapter 11 process, get some of its debts discharged, and move out of Chapter 11 being a more profitable company and being able to get back on its feet and operate and re-employ its employees so that it not only helps the debtor but helps the overall economy. Loic, if you want to move to the next section.
Thank you, John.
Loic, if you want to talk a little bit about this practical advice for today's market, that'd be great.
Thanks, John. And now we want to move into just providing some practical pieces of advice, both generally and in light of the existing market and the COVID-19 pandemic. So the first piece of advice that we would provide is that you don't ignore signs of financial distress. We know that oftentimes people can get so bogged down with their work, or in some cases willfully disregard sometimes blatant signs that the enterprise is really struggling. And in those cases, it's much more beneficial to the debtor and to the enterprise as a whole to be more upfront with the existing situation, to not wait until cash reserves and capital and financing completely depletes itself. Again, we want to reiterate that bankruptcy can be expensive, and you don't want to wait till it's too late to either make use of your cash reserves or arrange for DIP financing. Oftentimes, reaching out to the appropriate turnaround professionals or restructuring professionals can save an otherwise doomed enterprise if they acknowledge their situation early enough and respond accordingly. And then we also want to encourage keeping an open line of communications with your existing creditors. I know it may seem as if Debtors may be concerned or unwilling to acknowledge their realities and particularly communicate that reality to their existing creditors, but it's often far more beneficial to the debtor to be upfront about the situation and work with their existing creditors, particularly given that everyone's essentially going through the same ordeal right now. We're all going through the same COVID-19 market, and everyone's pretty understanding that there's some larger macroeconomic factors here that are beyond our control that hopefully in the near future will be lifted, and that the enterprise will be able to continue to function to some degree or another as it did prior to COVID-19. And so concealing and not having an open line of communications creates uncertainty on the part of the creditors and may actually ultimately result in the creditor forcing the debtor into bankruptcy prematurely.
Loic, if I might chime in here, I think re-emphasizing all of these points is very important for a company that might be experiencing financial difficulties. Often over my career, I've been approached by clients who have waited till the absolute last minute to talk to a professional about the possibility of bankruptcy and what their options might be, and that often puts them in a very difficult situation and makes reorganization much harder. So the earlier you identify potential problems and attempt to address them with a professional, the better. Also, keeping an open line of communication with your creditors is important. Many times, if you do that and you show them that what you're doing to plan for the future and try to dig out of whatever hole you are in, the debtors will work with you, or the creditors will work with you. And if they work with you, you may be able to avoid bankruptcy altogether. Put together some type of forbearance agreement with one or two of the creditors and work with other creditors in various different ways to prevent a bankruptcy filing altogether. So if you can keep the communication lines open with creditors, I can't emphasize the importance of that enough.
Thank you, John. The next piece of advice we would provide is that you identify key employees that have access to information and otherwise a fundamental understanding of the business, its operations, and its financial position. Identify these individuals and coordinate with them at the beginning of the process so that you can best plan and work with the resources that are available to you. So make use of those individuals to the maximum extent possible. John, I don't know if you had any other thoughts on that.
I think that you've outlined it well.
The next piece of advice really is just to consult with your legal professionals to review your underlying documents, your contracts, your leases, your loan agreements, check default provisions, notice provisions, grace and cure provisions, and ultimately the goal here is trying to search for any sorts of relief or leeway in your underlying contracts and documents. And you want to make sure that you are aware of all potential pitfalls, traps, or anything that could potentially trip you up unintentionally. And, it may seem like a burdensome process at the outset, but it in many cases can result in some very meaningful benefits for the enterprise.
I would also add that I think you can possibly find points of leverage with creditors by reviewing these documents in detail. Sometimes creditors think they have more leverage than they actually do, and by reviewing these contracts, you could find that they don't have certain leverage, and your negotiations with those creditors can be more fruitful.
We'd also encourage you to just identify your more burdensome contracts for purposes of immediate rejection or assumption, and really take a deep dive into the enterprise and figure out what it is that's causing the enterprise to struggle, and then explore what bankruptcy restructuring tools may be available to you, or other tools that may be available to you outside of the bankruptcy context that can help alleviate some of the internal issues that the organization is going through. So, you may be experiencing just a very specific contract that is resulting in the enterprise hemorrhaging cash, or a particular compensation structure or something or another that may be the source of your majority or large part of your problems, and so taking a deep dive into the enterprise and figuring out which individual pieces you want to focus your attention on at the outset of the process can be very beneficial. John, I don't know if you had any other thoughts on that piece.
No. Well, I think we've covered that.
And then from the creditor standpoint, something that you can do, and we strongly encourage you to do, is identify your most at-risk debtors. And so this may be difficult to the extent the debtor is not having an open line of communication, but I think oftentimes, given the business relationship, we can see signs. And when you see those signs, we encourage you to respond to them accordingly. You don't have to be aggressive or anything like that, but you can certainly just give your vendors, your customers, et cetera, just a call and kind of discuss where you stand in light of the current climate and where they stand and how you guys can collaborate. As part of that process, you want to beware of preferential treatment. And the reason why we say beware of there, in that case, the way preferential treatment can come back to bite you is to the extent you receive certain benefits payments prior to the filing of the bankruptcy that can be clawed back. But we, in very rare cases, would we encourage or advise someone against actually retaining or accepting any type of agreement or negotiation or plan or payment with your creditors. In those cases, we would encourage you to go ahead and take the payment and then respond accordingly to the extent that there are issues down the line. John, I don't know if you disagree or agree or have any other thoughts on that piece.
No, I heartily agree with that. I think that almost to a person over my career, I have advised creditors to accept payments from debtors, even if they believe those debtors are about to file bankruptcy and those payments are payments of past due debts. First of all, the chance that the money is going to be clawed back is not 100%. You may be able to keep the money, and even if a clawback action occurs, you're typically going to be able to settle that for significantly less than you were paid in the first place, because there are numerous defenses to those preference matters. And so it's definitely in your best interest as a creditor to accept any money that the debtor is willing to pay you on past due debts and worry about the clawback later, as long as you're aware of it. I think that's sufficient.
The next piece that we'd advise here is just to be aware of the automatic stay and do not violate it. Intentional violators may be subject to hefty penalties. And we do want to acknowledge the reality of, the powers of the automatic stay in connection with various other mechanisms and regulations that are coming out by local and state and federal authorities with regards to enforcing certain rights and collecting on certain rights. It can be difficult for creditors to actually take full advantage of rights that they would otherwise have, but you want to make sure that you're mindful of those prohibitions and, to the extent possible, avoid violating them. I know it may seem appealing initially to go ahead and try to collect, but generally down the line it can be quite detrimental and not really worth the effort.
And I guess I would emphasize that the automatic stay in bankruptcy is very broad. It's automatic. It comes into being immediately upon the filing of the bankruptcy case. Even if you're in the middle of a collection action, that collection action is stayed. You can't take any more steps to try to collect money on a past due debt, even if a court case has been filed. So once that bankruptcy is filed, I would contact a professional if they believe you have justification to get relief from the automatic stay. Maybe you go into court and ask for it, but do not take any action on your own.
Well, finally, just generally, you want to keep strong records for the business, and in particular, that's in regards to a creditor or a debtor that you anticipate may be having difficulties. And you want to take note of, the delivery date of all products and services. Preferential treatment may be provided in certain cases. It's a slight typo there. That's supposed to be within 20 days. So To the extent services or products are delivered within 20 days of filing, preferential treatment may be accorded in those circumstances. And you may also take advantage of a reclamation claim that can be filed to the extent services or products are delivered within 45 days. So taking note of details of your relationships with your various creditors and, your various debtors, in particular those that you anticipate or foresee are going through financial distress, and making sure that you keep adequate records to take advantage of some of these remedies is essential.
Yes, if I'm contacted by a creditor who's got a customer who is about to file bankruptcy or who has filed bankruptcy, these are some of the first questions I'm going to ask. What products have you delivered? When have you delivered them? How much is due? We're going to look to try to get priority claims for as much of that product as possible, or get the product back. Those are the first two things we're going to try to do. We're also going to contact the debtor, not to try to collect any debt, but to find out what the debtor's intentions are with regard to the creditor going forward. So that information that's in that third bullet point is important if a customer files bankruptcy.
Moving on, we, to the extent possible, encourage renegotiating, modifying your relationships with your existing debtors, modifying payment terms that work in the interest of all parties, requiring additional security, or simply ceasing conducting business with those particular debtors. And John spoke, or at least he referenced, entering into various forbearance agreements and things like that. That may be worth the effort to the extent that you foresee that a particular debtor is going into financial distress. And then some cleanup.
I'll jump in here real quick, just because there are two different aspects to this. One is before the bankruptcy. If you see a debtor going into financial distress and they're getting further and further behind on their account payable, reach out to them, talk to them if you can work together to put together some type of agreement, payment agreement, to avoid the lawsuit and get the money collected, especially in these times. I think that makes sense. The other aspect of this is after the bankruptcy is filed, if one of your customers files a bankruptcy, understand that you are not required to continue to deal with that customer. Many suppliers are incentivized to deal with those customers because obviously if they sell them product, they make a profit on it. But you do not have to deal with them. You can deal with them in significantly different ways. If you have them on terms, you can cut those terms off and make it cash on delivery or cash in advance terms. So there are different ways that you can deal with a customer who has filed bankruptcy, and the bankruptcy code or the automatic stay does not prevent you from changing those terms going forward. The automatic stay simply says you cannot collect any debt that was due on the date of the bankruptcy filing.
Thank you, John. And then just the last piece of advice there is just to make sure you have all your ducks in a row. Confirm that all security interests have been properly perfected. File a proof of claim with the bankruptcy court as soon as possible, and just to make sure that you're doing crossing all your T's and dotting all your I's, and ensuring that all rights that you may have as a creditor are secured and available to you. And with that, that's the end of our presentation there. Thank you, John, and everyone else for joining us. I don't see any questions. John, let me know if you see any.
No, I will say that if anyone on this call has questions later on that come up, please feel free to contact either Loic or myself. We'll be happy to try to answer them for you or address any situations that you might have.
Thank you, John. And we also want to just give a quick reference to the Miller Johnson's Back to Work Resource Center. It's a resource that we provides continued and updated information and resources in connection with reopening, providing and ensuring that you're providing a safe workplace for their various employees and helping all of our clients navigate that process in a safe and effective manner, in a manner with that's consistent with all applicable regulations and rules that are coming out almost on a daily basis. So if any questions, if anyone has any questions on that piece or that resource, feel free to reach out. And if you have questions on anything else, feel free to reach out, and we're happy to help. Thank you so much for the time this morning.